All right, let's slow this down and reset the conversation. Because over the last few days, there has been a flood of viral claims, dramatic headlines, and social media threads suggesting explosive legal action involving former President Donald Trump, the Supreme Court, asset freezes, and even testimony from Melania Trump. A lot of people are asking what is real, what is rumor, and what is legally possible under U.S. law. So today, instead of reacting to viral posts, we're going to walk through what is actually confirmed, what is legally plausible, and what would need to happen for some of these dramatic scenarios to become reality. This is not speculation dressed up as fact. This is a breakdown of how the law actually works, based on verified public reporting and established legal procedures. First, let's talk about the Supreme Court. The Supreme Court does not conduct live fact-finding trials the way lower federal courts do. It hears legal arguments. Attorneys present constitutional questions. The justices interpret the law. There are no surprise witnesses walking in to deliver dramatic testimony in the middle of proceedings. That's not how it works. If you see claims about someone testifying in front of the Supreme Court under oath in a dramatic courtroom setting, understand that Supreme Court proceedings are structured around legal argument, not evidentiary hearings like a criminal trial. Now, could the Supreme Court rule on issues related to presidential immunity or asset seizure? Yes, that's within its authority. In fact, the court has already heard arguments related to presidential immunity in ongoing federal cases involving Donald Trump. That part is real. There are active cases moving through the courts involving federal indictments and questions about the scope of executive immunity. But here's what's important. Asset forfeiture and seizure orders typically originate in federal district courts. They require detailed filings, evidentiary standards, and judicial review at the trial level. U.S. Marshals execute seizure warrants only after lower courts issue enforceable orders. The Supreme Court does not dispatch marshals directly as an immediate reaction to live testimony. It reviews legal questions after lower court rulings have already occurred. That distinction matters. Now let's address the broader issue of spousal testimony, because that has also been circulating in online discussions. Under U.S. law, there are two primary types of marital privilege. The first is spousal testimonial privilege, which in certain circumstances allows one spouse to refuse to testify against the other in criminal proceedings. The second is marital communications privilege, which protects private communications between spouses. However, these privileges are not absolute. They can be waived. They don't apply in every context. And courts have carved out exceptions over decades of precedent. For example, if both spouses are involved in alleged criminal conduct, privilege arguments become more complicated. If communications involve furtherance of a crime, privilege may not apply. But again, those are determinations made in trial courts, through formal motions, with detailed legal analysis. They are not decided in a single dramatic moment. Another claim circulating online involves massive asset freezes tied to ongoing indictments. So let's clarify what we actually know about federal indictments involving Donald Trump. There are confirmed federal cases, including matters related to classified documents and election interference allegations. Those are public record. They are moving through the judicial system in stages. Motions are filed, appeals are made, deadlines are set. It is a slow, procedural process. Large-scale asset forfeiture tied to those cases would require prosecutors to demonstrate that specific assets are directly connected to alleged criminal conduct. That is not automatic. It requires evidentiary hearings, legal challenges, and often months or years of litigation. When you see headlines claiming billions of dollars frozen overnight, the first question should always be, which court issued the order, under what statute, and where is the public filing? Federal court records are accessible. Real seizure orders leave a paper trail. Let's also address the political timing argument, because that comes up whenever legal action intersects with an election cycle. Courts do not stop functioning during election years. Indictments and hearings continue based on procedural calendars. However, political observers often interpret legal developments through a political lens. That tension is not new. We saw it during Watergate. We saw it during the Clinton investigations. We saw it during prior administrations. Legal timelines and political timelines frequently collide. But that collision does not automatically mean coordinated strategy. It can simply mean the judicial process is moving forward. Now let's talk about cooperation agreements and immunity, because those are real tools prosecutors use. When someone faces potential exposure, prosecutors may offer limited immunity in exchange for truthful testimony. Those agreements are formal, documented, and usually disclosed in court filings. They are not secret handshake deals that remain invisible to judges. If any high-profile figure were to receive immunity in a federal case, that would be documented in motions and filings. Defense attorneys would challenge it. The press would report on it. It would not appear as a sudden, unexplained twist. Another major claim involves attorneys facing obstruction charges connected to advising clients on financial transfers. Here's how that works in reality. Lawyers can face criminal charges if prosecutors believe they knowingly participated in fraud or obstruction. That does happen in white-collar cases, but it requires strong evidence of intent. Merely giving legal advice that later turns out to be incorrect is not automatically criminal. There has to be proof of knowing participation in unlawful conduct. Federal prosecutors are extremely cautious about charging attorneys because it raises complex privilege issues and constitutional concerns. It is not something that happens casually or overnight without substantial investigative groundwork. So when evaluating viral claims about lawyers being arrested immediately after a court appearance, the question again is, where are the charging documents? Federal criminal complaints are public record once unsealed. They detail statutes, facts, and probable cause. Without those documents, claims remain unverified. Let's zoom out for a moment. The reason stories like this spread so quickly is because they combine three powerful elements: money, power, and family. Add the Supreme Court, and you have a narrative that feels cinematic. But the American legal system is procedural, layered, and documented. Dramatic shifts require written orders. Written orders require jurisdiction. Jurisdiction requires a case posture that fits within statutory authority. That doesn't mean major legal consequences are impossible. It means they don't materialize through surprise announcements. Now here's what is real and worth watching. The Supreme Court has shown interest in clarifying the boundaries of presidential immunity. That issue has long-term implications for future administrations, not just for one individual. If the court narrows or expands immunity doctrine, it will shape executive accountability for decades. That's significant. Additionally, federal prosecutors in ongoing cases continue to litigate evidence disputes, privilege claims, and procedural challenges. Those filings are public. They are reported by major outlets. They evolve gradually, not through shock and awe maneuvers. And here's something else important. Asset forfeiture law is powerful, but controversial. Civil forfeiture, in particular, allows the government to seize property suspected of being connected to crime, sometimes before a conviction. Critics argue it can be abused. Supporters argue it prevents asset flight and preserves restitution funds. If any case were to involve large-scale forfeiture tied to high-level political figures, it would spark intense constitutional scrutiny. That scrutiny would play out over months, not hours. Let's talk about market reactions, because that also gets exaggerated. Financial markets respond to uncertainty. If there are credible reports of major legal developments involving a former or sitting president, volatility can increase temporarily. But sustained market movement depends on confirmed information, not viral speculation. Institutional investors do not rebalance portfolios based on anonymous posts. They respond to filings, rulings, and verified news. Another issue raised in online discussions is executive privilege. Executive privilege protects certain communications within the executive branch. It does not provide blanket immunity from criminal investigation. Courts have ruled repeatedly that privilege yields to demonstrated need in criminal proceedings. That precedent goes back to United States versus Nixon during Watergate. So if privilege claims arise in ongoing litigation, courts analyze them carefully. They don't simply dismiss them or accept them wholesale. Now let's address the human dimension, because even when legal cases are high profile, there are real people affected. Employees at properties, staff members, contractors, vendors. They all watch headlines and wonder what it means for their jobs. That's true in any major corporate or political investigation. Uncertainty creates ripple effects. But again, major operational changes follow formal legal orders, not rumors. Here's the broader takeaway. In a digital environment where speed outruns verification, the most powerful thing you can do is check the source. Is there a docket number? Is there a filed motion? Is there a signed order from a judge? Federal courts publish these documents. They don't operate in secrecy for long in high-profile cases. If a Supreme Court emergency order were issued, it would appear on the court's official website. If U.S. Marshals executed seizure warrants, those warrants would trace back to specific district court orders. Paper trails exist. And that's where responsible coverage begins. Now, Over the next few days, there are legitimate dates to watch in ongoing federal proceedings, motion deadlines, appellate filings, scheduling conferences. Those are the real inflection points. Not viral timestamps, not anonymous leaks, but docketed hearings. As we move forward, here's what informed observers are monitoring: how courts interpret presidential immunity claims, how lower courts handle evidentiary disputes, whether appellate courts accelerate review timelines, and how prosecutors structure their arguments. Those are concrete developments. It's also worth noting that political rhetoric from any side often frames legal processes as persecution or as overdue accountability. That's part of the public debate. But inside courtrooms, judges focus on statutes, precedent, and procedural rules. Emotional narratives rarely carry weight in written opinions. So if you're trying to separate signal from noise, focus on written rulings. One more point about spousal privilege, because it's widely misunderstood. Even when testimonial privilege exists, it belongs to the witness spouse in federal court. That means the spouse can choose to testify. Courts have recognized that autonomy, so if in any case a spouse elects to provide information, the analysis centers on whether privilege was properly waived, not whether it existed in theory. But again, that discussion happens in motions, not in dramatic televised confrontations. Let's pause here and be clear about something. The American legal system is capable of dramatic outcomes. Presidents have resigned. High-ranking officials have been convicted. Massive settlements have been imposed. But those outcomes emerged from documented investigations that unfolded publicly over time. There are no shortcuts in federal litigation. If new verified filings appear, they will change the landscape. If appellate courts issue major rulings, those rulings will be published and analyzed. Until then, caution is not weakness. It's discipline. In the next segment, we're going to walk through what would actually need to happen step by step for large-scale federal asset forfeiture tied to a political figure to become enforceable, and why each step involves procedural safeguards that can't be skipped, because understanding that chain is the key to understanding why so many viral claims collapse under scrutiny once you look at how the system really works. And to see how that process begins, you have to start at the investigation phase, where federal agents gather financial records, subpoena documents, and build a case long before any public courtroom moment ever takes place. And that phase alone can take months or even years depending on the complexity of the transactions involved, especially when international accounts or cross-border financial institutions are part of the picture, because cooperation between jurisdictions requires formal requests, treaties, and compliance with foreign banking laws, which means nothing moves instantly, no matter how dramatic the headlines may sound. And once investigators believe they have sufficient evidence, they present that evidence to a grand jury. And that grand jury process is itself confidential, structured, and deliberate. Prosecutors lay out documents, testimony, financial records, and investigative findings. Grand jurors ask questions. They decide whether probable cause exists to issue an indictment. That doesn't happen in a single afternoon because of a headline. It happens after evidence has been gathered, organized, and legally vetted. If an indictment is returned, and prosecutors believe certain assets are tied directly to alleged criminal conduct, they then file motions in federal district court seeking seizure or restraining orders. Those motions must cite specific statutes. They must outline the factual basis for connecting property to alleged offenses. A judge reviews that request. The defense has the opportunity to challenge it. There are hearings, there are written responses, there are appeals. That's the chain. In high-profile cases, especially those involving politically exposed individuals, judges are acutely aware that every procedural step will be scrutinized. That usually makes the process slower, not faster. Courts want clean records. They want carefully written orders that can withstand appellate review. If a judge grants a seizure order, it will describe the property, the legal basis, and the scope of enforcement. It won't be vague. It won't be implied. It will be written and signed. Then, and only then, can enforcement agencies act. U.S. Marshals execute court orders. They do not independently decide to freeze assets. They enforce what judges authorize. And if property is seized, there is still a process for the property owner to contest forfeiture. That can involve hearings, motions to release assets for legal expenses, constitutional challenges, and sometimes negotiated settlements. That's why when you see claims about billions of dollars permanently gone within hours, you should immediately ask, has there been a final forfeiture judgment? Because without a final judgment, seized property is typically held pending trial or resolution. Now let's talk about appeals. Because appeals change timelines dramatically. If a district court issues a controversial order, the defense can appeal to the circuit court. In rare circumstances, they can seek emergency relief from the Supreme Court. But even emergency applications require written briefs. The opposing side responds. Justices review those filings. Orders are issued in writing. Emergency does not mean chaotic, it means expedited. The Supreme Court often issues short orders in emergency applications. Sometimes they include no explanation, but those orders are still grounded in prior filings and lower court rulings. The court does not originate factual disputes from scratch. It reviews what has already been developed in the record. That's why understanding the record matters so much. Now, on the subject of attorney liability, because that's another area where misinformation spreads quickly. Attorneys advising clients in complex financial matters operate within professional responsibility rules. If prosecutors suspect lawyers cross the line into active participation in criminal schemes, they would typically build cases carefully, often using cooperating witnesses, financial trails, and communications evidence. Charging an attorney is not symbolic. It requires proof of intent. It can also trigger additional litigation over attorney-client privilege, work product doctrine, and Sixth Amendment rights. Courts tread carefully in this area because of the implications for the legal system as a whole. So if you ever hear that multiple attorneys were arrested overnight in connection with advice they gave, the first thing to look for is the criminal complaint. It will specify statutes such as obstruction of justice, conspiracy, wire fraud, or money laundering. It will describe overt acts. It will lay out probable cause. Without that document, the claim is incomplete. Let's pivot to the political response dynamic, because whenever legal developments involve high-profile figures, public statements follow quickly. Political leaders often frame legal action as either accountability or persecution. Supporters echo those frames. Opponents amplify their own interpretations, but public statements are not legal rulings. Inside the courtroom, judges do not weigh press conferences. They weigh evidence, statutes, and precedent. Written opinions are grounded in legal reasoning, not campaign messaging. Now, about immunity. Federal immunity agreements can be transactional, covering specific acts, or broader use immunity that protects against certain prosecutions based on compelled testimony. But immunity agreements are formal. They are negotiated. They are documented. They are often disclosed to the court to clarify the scope of protection. If a witness were cooperating in a major federal case, defense teams would analyze the immunity terms closely. They would question credibility. They would cross-examine based on potential incentives. All of that would become part of the public record if the case proceeds to trial. So when immunity is discussed online without documentation, it's speculation until proven otherwise. Let's also address the economic narrative that often follows large legal stories. Claims that seized funds automatically go to the Treasury and materially impact taxpayer burdens oversimplify how federal finances work. Forfeited funds may be allocated to specific enforcement funds or victim restitution depending on statutory frameworks. They do not instantly reduce individual tax bills. Federal budgeting is far more complex than that. Similarly, short-term market volatility tied to political legal news tends to stabilize once facts are clarified. Institutional markets price risk based on credible information streams, not rumor cycles. Another frequently misunderstood concept is contempt. Courts can hold individuals in contempt for failing to comply with lawful orders. But contempt proceedings also require process. Notices are issued, hearings are held, findings are entered on the record. Contempt at the Supreme Court level is extraordinarily rare and would involve formal procedural steps. Nothing in federal litigation materializes in secret and explodes publicly without a trail. Now, here's something else worth understanding. In high-profile investigations, leaks do happen. Anonymous sourcing appears in media coverage, but responsible outlets typically corroborate claims with documents or on-the-record confirmation. When multiple independent reporters confirm filings and provide docket references, credibility increases. When claims circulate without documentation, skepticism is healthy. This is especially important in the current digital environment where AI-generated narratives, edited clips, and fabricated documents can spread quickly. Verification is not optional, it's essential. If you want to track real developments, monitor official court websites. Federal district courts publish dockets. The Supreme Court publishes orders. Appellate courts release opinions. These sources are primary. Commentary follows. Documentation leads. Let's talk about precedent, because precedent shapes future cases. If appellate courts clarify limits on executive immunity, that interpretation binds lower courts within that jurisdiction. If the Supreme Court issues a broad ruling, it binds the entire federal system. That's why immunity cases are watched so closely. They define the scope of presidential accountability going forward. But again, those rulings emerge from written opinions after argument, not from surprise testimony events. On the human level, legal uncertainty can create real stress for employees and families connected to organizations under investigation. Payroll concerns, contract uncertainty, reputational impact, all of that is real. But employment consequences flow from operational decisions and court orders, not from unverified social media claims. Now, stepping back, why do elaborate legal narratives gain traction so fast? Because they combine recognizable institutions with dramatic stakes: the Supreme Court, federal marshals, billion-dollar figures, international accounts. Those elements create a sense of urgency and scale. But scale requires proof. As of now, the confirmed legal landscape involves ongoing federal cases moving through procedural stages, appellate arguments about presidential immunity, and continued litigation over evidence and scheduling. Those are documented realities. Anything beyond that requires documentation. Here's what to watch next in any major federal case: scheduled hearings, motion deadlines, appellate briefing schedules, and published opinions. Those events are predictable and visible. They shape outcomes incrementally. And one final point about timing: courts do not coordinate with election calendars as political strategy. Judges are appointed for life precisely to insulate them from electoral cycles. That doesn't eliminate public perception of political impact, but it does mean rulings are grounded in legal analysis rather than campaign considerations. So if you're evaluating dramatic claims, ground yourself in process. Ask what statute applies. Ask which court has jurisdiction. Ask whether there is a written order. Ask whether there is a docket number. Those questions cut through noise. As we move into the coming weeks, if any verified developments occur in ongoing federal litigation, they will be accompanied by filings you can read. They will be analyzed by legal scholars across the ideological spectrum. They will be debated in courtrooms, not just on timelines. Until then, discipline matters more than drama. We'll continue tracking confirmed filings, appellate decisions, and official court actions. When documents drop, we'll break down what they actually say, not what viral posts claim they say. That's how you stay informed without being misled. Because at the end of the day, the American legal system runs on written records, procedural safeguards, and appellate review. It's slower than social media. It's less theatrical than rumors. But it's real. And that's what we focus on here. And before we wrap this up, I want to zoom out even further and talk about why understanding legal mechanics is so important in moments like this, especially when stories involve names everyone recognizes. When you hear about investigations tied to a former president, your brain immediately jumps to historic comparisons. Watergate, Iran-Contra, Clinton impeachment. Those were defining chapters in American political history. But if you go back and study them carefully, you'll notice something consistent. None of those events unfolded overnight. They were built case by case, motion by motion, hearing by hearing. Watergate began with a break-in. It evolved into congressional hearings. It involved special prosecutors. It went to the Supreme Court on questions of executive privilege. That ruling, United States versus Nixon, was written and reasoned. It didn't materialize out of thin air. It followed months of litigation and argument. The same pattern applies today. If courts are evaluating presidential immunity, they are doing so based on briefs filed by attorneys, prior case law, constitutional text, and oral arguments recorded and transcribed. If prosecutors are pursuing financial crimes, they are relying on statutes governing wire fraud, money laundering, obstruction, or conspiracy. Those statutes have elements. Each element must be proven beyond a reasonable doubt in criminal court. That burden is high by design. So when dramatic financial figures circulate online, like claims of hundreds of millions moved in defiance of court orders, the legal question becomes very specific. Was there an enforceable freeze order in place? What did the order cover? Who had signatory authority? Were transfers executed before or after notice? Was there intent to violate the order? Each of those questions requires evidence: bank records, communications, testimony. And that evidence, if it exists, gets filed, challenged, and tested. Another thing people often overlook is how appellate review shapes outcomes. Even if a district court makes a controversial decision, circuit courts can affirm, reverse, or remand. The Supreme Court can step in if constitutional questions are at stake, but that ladder of review exists precisely to prevent rash or procedurally flawed rulings from standing. So when someone claims that a single testimony triggered sweeping irreversible consequences, pause. The federal judiciary is layered. Safeguards exist. Let's talk briefly about the difference between civil and criminal proceedings, because that distinction matters in asset-related cases. Criminal forfeiture is tied to conviction. Civil forfeiture can proceed against property itself under certain statutes, even without a criminal conviction. But civil forfeiture cases still require notice, the opportunity to contest, and judicial findings. Property owners can demand hearings. They can argue innocent ownership. They can challenge probable cause. Nothing is automatic. And in high-profile cases, judges are typically meticulous in documenting their reasoning because they know their decisions will be appealed and publicly scrutinized. Now consider the information ecosystem. A rumor appears. It cites page numbers, dollar figures, and procedural steps. It sounds authoritative. It spreads rapidly. But if those page numbers don't correspond to an actual docket, if those figures don't appear in verified filings, the narrative rests on sand. That's why primary sources matter more than screenshots. In modern political discourse, there's also a tendency to treat complex legal developments as moral verdicts. If you support someone, you interpret legal pressure as persecution. If you oppose them, you interpret it as justice catching up. But the legal system does not operate on moral alignment. It operates on proof, procedure, and precedent. And sometimes outcomes disappoint both sides because legal standards are narrower than political arguments. Another key point involves cooperation. When prosecutors build complex cases, especially involving financial transactions across jurisdictions, they often rely on documentary evidence more than dramatic courtroom exchanges. Paper trails, compliance reports, transaction timestamps, corporate filings, those are the backbone of financial litigation. If cooperation agreements exist in any major case, they will eventually surface in formal proceedings. Defense teams will cross-examine cooperating witnesses. Motions will challenge admissibility. Judges will rule. That's the rhythm of federal court. It's not cinematic, it's technical. Let's also address the idea of emergency Supreme Court intervention. The court does have what's often called the shadow docket, where emergency applications are resolved quickly. But even those decisions are based on filings submitted in writing. They are not spontaneous reactions to live testimony. They are responses to formal applications for stays, injunctions, or relief. And even then, the court often provides minimal explanation, which fuels speculation. But the underlying record still exists. So if in the future you see claims of emergency orders, check the court's official order list. It's public, it's time-stamped, it's archived. Now, on the question of political ramifications, legal cases can influence campaigns indirectly by shaping public perception, but judges do not weigh polling data in their rulings. Their opinions cite precedent. They reference constitutional interpretation. They analyze statutory language. That insulation is intentional. It doesn't eliminate controversy. It channels it into legal argument rather than public spectacle. One more dimension worth noting is the international component that often appears in viral narratives. When financial transactions involve foreign banks, U.S. prosecutors must use mutual legal assistance treaties to obtain records. That process can take months. Foreign jurisdictions have their own privacy laws and compliance requirements. There are diplomatic layers involved, which again underscores why instant global asset sweeps are highly unlikely without prolonged groundwork. If you're someone who follows financial regulation, you know that cross-border enforcement is complex. It requires coordination between agencies, adherence to international agreements, and careful documentation. So when evaluating sweeping claims involving multiple jurisdictions, ask whether there has been any confirmed international cooperation announcement. Those are usually public because they involve governmental coordination. Let's also consider the role of congressional oversight. Congress can hold hearings, request documents, and conduct investigations separate from criminal proceedings. But congressional hearings are political and informational. They do not impose criminal penalties directly. They can refer matters to the Department of Justice, but prosecution decisions remain within the executive branch. That separation of powers is foundational. If Congress schedules hearings related to executive accountability or asset management, those hearings will be announced publicly. Witness lists will be published. Testimony will be recorded. That transparency is part of the process. At the end of the day, the reason we emphasize documentation over drama is simple. The stakes are too high for guesswork. When discussions involve the presidency, constitutional doctrine, and large financial claims, accuracy matters more than speed. So here's the practical takeaway. If you want to stay ahead of the curve without being misled, build your information diet around primary sources and reputable reporting. Watch for official filings. Read summaries from multiple outlets. Compare interpretations. Avoid conclusions that depend entirely on unnamed sources and missing documents. Legal systems move deliberately for a reason. They are designed to balance power with due process. And if major developments occur, they will leave fingerprints in the public record. In the final segment, we're going to tie all of this together and outline exactly what would constitute a verified escalation in any ongoing federal case involving high-level political figures, so you know precisely what to look for instead of relying on viral narratives, because understanding the markers of real legal movement is the difference between reacting emotionally and analyzing responsibly. And once you understand those markers, you'll never look at sensational legal headlines the same way again. So let's close this out by defining those markers clearly. What would count as a confirmed escalation in a federal case of this magnitude? First, a publicly filed indictment or superseding indictment detailing new charges. That document would include specific counts, statutes cited, factual allegations, and the signature of a federal prosecutor. It would be accessible through court records and reported widely. Second, a written order from a federal district court granting or expanding asset seizure authority. That order would identify property, outline the legal basis, and specify enforcement mechanisms. It would not be vague. It would be precise. Third, an appellate ruling from a circuit court or the Supreme Court clarifying constitutional questions such as immunity or executive privilege. That ruling would be published. It would include legal reasoning. Scholars across the country would analyze it line by line. Fourth, formal criminal complaints against additional individuals, accompanied by affidavits establishing probable cause. Those affidavits would describe alleged conduct in detail. If you don't see those documents, you are not looking at a confirmed escalation. Everything else is narrative. Now, none of this means that serious legal consequences are impossible in any ongoing investigation. It means that when they occur, they will follow documented steps. They will not rely on anonymous summaries alone. They will withstand scrutiny because they are rooted in process. And process is what ultimately defines the legitimacy of outcomes in a constitutional system. The American judiciary is not perfect. It faces criticism from every ideological direction. But its authority rests on transparency and reasoned decision-making, written opinions, public hearings, appeal rights. That structure is what separates rule of law from rumor cycles. So as headlines continue to circulate, anchor yourself in what can be verified. Ask for documents. Ask for jurisdiction. Ask for statutory authority. That approach doesn't dull the story. It clarifies it. We'll continue monitoring official filings and confirm developments. If courts issue significant rulings, we'll break down what they actually say and what they don't say. If prosecutors file new motions, we'll analyze the statutes involved and the likely legal arguments on both sides. Because informed analysis isn't about amplifying the loudest claim. It's about understanding the framework that determines whether a claim holds weight. In moments of high political tension, that discipline is more important than ever. So stay focused on the record. Stay skeptical of unverified specifics. And remember that in federal court, nothing replaces a signed order and a docket number. That's where the real story lives.